Good evening. My name's Joellen Riley. I'm the Dean of Sydney Law School, and it's my great privilege to welcome you all to the 4th George Winterton Memorial Lecture tonight. I'd like to start by acknowledging the Gadigal people of the Eora Nation, who are the traditional custodians of this land, and I'd like to pay respect to their elders, both past and present, and to extend that respect to other Aboriginal Australians who are present tonight. I have many eminent guests to welcome, especially this evening. Of course, the Winterton family, especially Mrs. Rosalind Winterton and Dr. Peter Winterton, and all of the members of the family who are here. Chief Justice Tom Bathurst, our very generous host for this evening's lecture, who's organised our ability to hold this in the Banco court tonight, which we appreciate very much. Chief Justice James Alsop of the Federal Court now, Justice Margaret Beasley, Justice Stephen Gaigler, I've noticed here from the High Court also, Sir Gerard Brennan, we're very pleased you've joined us again this evening. All of your honours, many eminent guests here, my academic colleagues, our wonderful students who've ushered you in this evening, Sydney University's best and brightest. In fact, all of our friends from the profession, we're very pleased that you've come again to this very important recognition of George Winterton's incredible contribution to constitutional law scholarship. My task is simply to introduce our main MC tonight, Professor Peter Gerangelos. Professor Gerangelos is the convener of the Winterton Lecture Series. He was appointed last year as the Chair of Constitutional Law at University of Sydney, which post was in fact last held by George Winterton. Peter has taught and collaborated with George over many years at this university when he joined the faculty from the Office of the Australian Government Solicitor. He was there the principal solicitor. Peter always describes himself as being particularly privileged to be George Winterton's doctoral student upon being awarded a Commonwealth Attorney General Scholarship for postgraduate research. Well, in fact, the Commonwealth Attorney General Scholarship for postgraduate research. He's also now carrying on George's tradition as lead author in the leading text, Winterton's Australian Federal Constitutional Law, and those of you who've been waiting patiently for a third edition, we can assure you that it's going to be published this year by Thomson Reuters. As George's great friend and colleague, it is indeed appropriate for Peter to introduce our guest and speaker for this evening. Thank you, Peter.
Thank you, Dean. Chief Justice, Your Honours, distinguished guests and colleagues, ladies and gentlemen. In 1983, two important books were published dealing with the constitutional issues raised by the 1975 dismissal. One written by a former Chief Justice of Australia, Sir Garfield Barwick, Sir John Did His Duty, the other being the major work of the future Professor of Constitutional Law in this university, George Winterton's Parliament, the Executive and the Governor-General. The Barwick and Winterton books were of course different in nature. The former dealt principally with the events of 1975, addressed expressly to the educated lay audience, setting out a defence of the dismissal. The latter was not limited to 1975, although Winterton did articulate a very nuanced position on the dismissal. It stemmed from his view that the framers of the Constitution made what he referred to as a miscalculation when they chose, I quote, to express the theoretical rather than the actual position of the Crown, being afraid of appearing gauche and uneducated in British eyes. He was referring in particular to their reticence to set out as precisely as they might the principles of responsible government, itself implied in the Constitution, which regulated the exercise of executive power by the Governor-General. I quote, "It can be an uphill battle," he wrote, "to maintain that the unwritten principles of responsible government should prevail over the express constitutional powers of the Governor-General, especially if the latter are read in isolation." To Winterton, this miscalculation, I quote, "sowed the seeds for future conflict. The first harvest," he said, being 1975. Winterton's book was more in the way of a scholarly treatise, like the other monographs in the prestigious series published by Melbourne University Press, Studies in Australian Federation, which included such classics as J.A. Lenore's The Making of the Australian Constitution and Geoffrey Saw's Federation Under Strain. It was the first major work dedicated to the broader question of executive power and its relationship to Parliament since H.V. Evatt's The King and His Dominion Governors, and the first dedicated more precisely to the executive power of the Commonwealth, although one must never overlook the influential papers by Professor Leslie Zines and Professor Jack Richardson, as well as the late Professor Enid Campbell on this issue in the interim, and I assure you that Winterton's copies thereof are heavily underlined and annotated. Now, permit me to pause here to acknowledge, especially this evening, the presence of Professor Leslie Zines, AO, oft regarded as the elder statesman of constitutional lawyers, and who was our speaker's postgraduate supervisor and a colleague over many years at the Australian National University, and we're very pleased to have you here this evening, Professor Zines. Now, the position taken by Winterton on 1975 was as much nuanced as it was disinterested, the culmination of years of dedicated study on executive power across a range of jurisdictions, preceding and including his days as a young Fulbright scholar and lecturer at Columbia University in New York prior to his return to Australia in early 1975. His position was in very general accord with that of Saw in Federation Under Strain, with some important variations, but it differed to the position taken in Sir John Did His Duty. It goes without saying that no one reading Winterton's book, and no one who knew Winterton as a scholar and a man, would doubt that his conclusion would stand irrespective of the political persuasion of the protagonists of 1975. Be that as it may, any mention of 1975 still tends to touch upon a raw nerve and to bring forth rash assumptions about a person's political proclivities. Winterton had to endure some of this. Amongst the Winterton papers is a review of the two 1983 publications. While glowing of Sir Garfield Barwick's work, it inappropriately juxtaposed Winterton's book, to which it tended to be unfavourable, even slightly dismissive, in stark contrast to the wide acclaim with which the book was otherwise received and continues to be received. The review did not pretend to appreciate the nuanced position of the Winterton thesis, tending to judge it on the basis of Winterton's position on the dismissal. And the review made the rather unique criticism, the first and only time I've seen such a criticism of a scholarly work, that Winterton's book contained over 100 pages of endnotes, which is not excessive really for a work of this type. They are an excellent resource in their own right, but they also manifest Winterton's deep scholarship and the pains he took to secure the unambiguously impartial foundation of his thesis. Reflecting on all this, the words of Francis Bacon's famous essay come to mind, the very same which inspired the title for the published collection of Sir Owen Dixon's extracurrial writings, "What is truth?" said jesting Pilate, and would not stay for an answer. 1975 renewed and cemented Winterton's commitment to remain in Australia and not heed the siren calls and offers to pursue his academic career in the United States. His letters to the Dean of Columbia Law School in 1975 reveal the torn emotions common to so many brilliant young Australians upon their return from the great universities of Europe and the United States, ironically a form of homesickness in reverse, which one hopes is experienced less acutely today. I will not say that a prophet is not without honour except in his own country, but perhaps we have not esteemed enough those who chose to stay when the world beckoned in comparison to those who did not. Professor Geoffrey Lindell, our speaker for this evening, was a very close friend and colleague of Winterton's, and with whom Winterton would discuss at length many difficult and complex constitutional issues, as Winterton did with Professor H.P. Lee of Monash, who is with us this evening, and Mr. Kevin Booker, his erstwhile colleague over many years. I'll have to run that one by Jeff, Peter. I can still hear ringing in my ears. With respect, they belong to a generation of constitutional scholars and teachers to whom we owe a great debt of gratitude and whose work has not achieved in Australia that degree of prominence beyond the circle of constitutional lawyers and jurists and, of course, their ever-grateful students, which it deserves. But then again, they were and are, as a rule, self-effacing and understated, reflecting those welcome and wholesome remnants of a less showy age. Why 1975 for the Winterton lecture? Principally because some critical issues remained unresolved, and because Winterton took a position on an aspect of 1975 as a young scholar which put him out on a limb, his propensity to disagree with Chief Justices evident even then. Has he been vindicated? More importantly, what is the constitutional position now, after nearly 40 years? And more precisely, what is the role of the courts? I will now allow our speaker for this evening to elaborate. Geoffrey Lindell is an adjunct professor of law at the Adelaide University and a professorial fellow at the Melbourne University, and was an adjunct professor of law at the Australian National University until 2010. Before his retirement as a full-time academic in 2002, he held senior academic positions at the Australian National University and later the Melbourne University. He has taught and published widely in the field of Australian constitutional law. He has assisted in some major reviews of the Australian Constitution by serving as a member of the Distribution of Powers Advisory Committee to the Constitutional Commission, 1986-7, and acting as a consultant to the Australian Constitutional Convention from 1975 to 1985. He has provided and continues to provide legal and constitutional advice to governments and parliaments, as well as having a standing retainer with the House of Representatives. He also appeared as counsel in 2 major High Court cases, constitutional cases. He was, until 2002, the inaugural Secretary of the Australian Association of Constitutional Law, a body he helped to form, and was a co-opted member of the Council of that association during 2005. Last year, he was made a member in the General Division of the Order of Australia for his service to legal education as an academic, particularly in the area of Australian constitutional law and through a range of professional associations. Professor Lindell's interest in the topic he will address stems from a long-standing interest in responsible government and also more broadly the study of the subject of justiciability, which began with the successful submission of his 2-volume LLM thesis, The Justiciability of Political Questions under the Australian and United States Constitutions. He's also the author, of course, of that entry on the same subject in the Oxford Companion of the High Court of Australia. And finally, although it may not be customary to do so on such occasions, I would like to mention that I have it on very good authority that Mrs. Elizabeth Lindell, who is with us this evening, and to whom Professor Lindell feels very much indebted for the loving support and understanding she has shown him throughout their marriage, had the unenviable and laborious task of assisting in the proofreading of his thesis and no doubt much else he has written. So it gives me great pleasure, ladies and gentlemen, distinguished guests, Your Honours, to welcome Professor Lindell to the podium.
Well, thank you very much, Peter. Chief Justices, Your Honours, ladies and gentlemen, thank you for coming. It's a bit of a daunting occasion, but nevertheless I shall try and do it justice. It's obviously a great privilege and pleasure to deliver a lecture which honours a very close friend and someone obviously who's a very distinguished academic lawyer, as Peter has explained, the late Professor George Winterton. It's hardly necessary, but I do join with the many others who have paid him richly deserved tributes for his excellent scholarship, teaching and other contributions to Australian public life. I again wish to place on record the warm and genuine personal encouragement he'd always provided me in the pursuit of my writing and research. Like his family and friends, I continue to feel very sad about his passing after he lost his courageous battle with illness. I miss very much the ability to discuss with him, sometimes I must confess at inordinate length, late into the night, constitutional and other issues of mutual interest and concern. It's pleasing to see in the audience members of his family, in particular his loving wife Ros, who provided him with such splendid support throughout his life, and of course George's brother Peter, Dr. Peter Winterton. Now, I think it's appropriate at this point to pay a tribute also to Professor Peter Gerangelos, who, with the support of successive deans of the Sydney Law School, the donors and obviously the administrative support staff, has and have ensured the establishment and continuation of this rather important lecture series. Now, I'm glad that I was able to choose a topic tonight which involves issues which I know were central to George's interests. In addressing that topic, I shall take us on what Hobbit filmgoers may recognise as an unexpected journey. When the Whitlam Labor government was dismissed in 1975, it was widely assumed that judicial review was not going to be available to challenge the validity of that dismissal, although there were some, of course, who did ask why Mr Whitlam chose to eat his lunch at the Lodge rather than going to the High Court. Well, since that time, developments have occurred both in Australia and elsewhere, which I think require us to revisit the correctness of that assumption. It's been questioned whether conflicts of this kind should be resolved by a pronouncement of a court. I will be suggesting tonight that if the courts resolve such conflicts in Australia, it will be because of what has happened since 1975 in two major areas of public law. The first relate to developments in administrative law which have undermined the assumption that Sir Owen Dixon once made that the normal rules which govern the exercise of discretions vested in ordinary government officials and bodies don't apply to those vested in a vice-regal representative. The second relates to the developments which may have had the effect of converting the core aspects of the conventions of responsible government into judicially enforceable rules. I intend to address whether, in the light of such developments, the High Court would and should intervene to review the legal validity of the dismissal of an elected government as a result of the Senate blocking supply. Now, the legal soundness of any such challenge will likely, I think, turn on two specific issues. The first is whether, if it was alleged that the dismissal breached the rules of procedural fairness, a court would apply to that dismissal those principles I mentioned a moment ago, the principles of administrative law which apply to those ordinary government officials, or would the court apply some other implied or much narrower principles which are more appropriate to regulate the exercise of constitutional prerogative powers. The second is whether a court would review and enforce some of the rules of constitutional convention which are derived from the principles of responsible government, as modified in their application to the Australian federal setting. In both cases, I'm not so much concerned with whether those rules or principles were actually breached in 1975, or indeed would be now if the situation were to be repeated today. Rather, my concern is going to be whether they apply so as to make any alleged non-compliance with them by the Governor-General susceptible to judicial review. By the way, although you'll hear me talking about justiciability today, I prefer the phrase susceptibility to judicial review, but you'll see what I mean in a moment. The lecture is in part prompted by judicial developments both in Australia and elsewhere, particularly in Papua New Guinea and other countries in the Pacific, which may result in courts having to resolve, as already indicated, conflicts over the reins of power, to quote the phrase once used by Professor Stanley de Smith. As Professor Winterton once reminded us, the first 5 justices of the High Court observed in the Governor of South Australia case, decided way back in 1907, that the dismissal of ministers by a vice-regal representative could not be reviewed by any authority but the sovereign. The question is whether this was still true by 1975, and if so, is it still true today? I've spent a lifetime contemplating the concept of justiciability and its opposite, non-justiciability, terms that the computer word processing programs still stubbornly refuse to recognise. As I've had occasion to explain before, it can mean different things in different contexts, which makes it all that more important to know which meaning is actually intended. For present purposes, it will suffice to repeat that those terms may refer to whether, as a matter of strict law, a court has authority to determine an issue, perhaps in that Mark Leeming sense, or whether an issue is suitable or fit for judicial resolution. In short, the difference between is and ought. These different meanings, however, are not unrelated, for whether a court ought to deal with an issue may well have an important bearing on the way in which a court will and should expound the relevant principles of law to avoid the determination of issues considered unfit for judicial determination. So far as the first of these senses is concerned, I've always believed in the utility of recognising that an issue may be non-justiciable, in other words, not subject to judicial review, by reference to 3 analytical grounds. First, A court may lack jurisdiction to deal with an issue in the narrow sense of jurisdiction because of the subject matter of the dispute, the nature of the parties involved, or because of the court's inability to grant appropriate judicial relief. Secondly, it may be argued by some that the court has jurisdiction but is not obliged to exercise it. I believe that the soundness of this latter argument is open to serious question if it is meant to suggest anything more than the exercise of the traditional discretions attached to the grant of prerogative writs and the forms of relief grounded in equity. Thirdly, even if a court has and is willing to exercise jurisdiction, it may be unnecessary for a court to determine the issue because the application of the relevant principles of law does not depend for their determination on the resolution of the issue. This may, for instance, be because the Parliament or the Government has acted within the scope of its legal powers and there simply is no relevant legal limitation on the exercise of those powers. I will only be concerned with the first and the third of these three separate grounds. I have never supported the second ground, which in effect rests on a discretionary view of the judicial function, leaving aside the already acknowledged discretions which attach to the grant of various kinds of judicial relief. I have always believed those discretions should be directed to the conduct of the individual parties to the dispute and the particular circumstances of the case, rather than whether certain aspects of the law can never ever be judicially enforced, regardless of who sues and whatever the circumstances. I believe a Prime Minister who has been or is about to be dismissed would be able to invoke the original jurisdiction of the High Court, at least to deal with a matter arising under or involving the interpretation of the Constitution. It should be possible for the same court to grant a declaration to such an aggrieved person as having a direct and material interest in the matter sought to be raised. It is unnecessary here to deal with whether the appropriate defendant to be sued should be the Governor-General or the Attorney-General of what would presumably be a caretaker government, or even the Commonwealth itself, since I believe at least one or other of these possibilities is likely to be accepted, and one is only necessary. Such actions have become more frequent in countries to our north and in the Pacific, which have inherited British systems of public law after they gained their independence. Perhaps the most recent instances have been in Papua New Guinea and Fiji. The actions have also dealt with the dissolutions of the Parliament. This development contrasts with earlier British dicta, which treated questions relating to the dismissal of ministers and the dissolution of parliaments as not being, by their very nature, susceptible to judicial review. I will return to that dicta later. It is true that the Papua New Guinea case of in re the reference to section 19(1) of the Constitution by the East Sepik Provincial Executive in 2011 evoked a rather unhappy spectre of two rival Prime Ministers, one recognised by the Supreme Court of that country and the other by the Parliament. Furthermore, judicial developments of the kind I have mentioned may well be thought by some to open the gate to the applications of the doctrines of necessity and effectiveness, which are more usually associated with countries less stable than our own. However described and whatever their differences, these are doctrines which involve, in short, legalising illegality. They are associated with what the German legal philosopher Hans Kelsen described as a change in the Grundnorm. It is little wonder then that in Luther and Borden, decided in 1849, the United States Supreme Court refused to entertain an action which effectively sought to determine whether the existing constitution of the state of Rhode Island, the so-called Charter Constitution, was displaced by the adoption of a rival constitution for the same state. Rival governments had been elected under both of those constitutions, believe it or not, and the case served as probably the earliest illustration of the American non-justiciable political questions doctrine. In that case, Chief Justice Taney was to observe as follows: if this court is authorised to enter upon this inquiry, as proposed by the plaintiff, and it should be decided that the Charter Government had no legal existence during this period of time, if it had been annulled by the adoption of the opposing government, then the laws passed by the legislature during that time were nullities, its taxes wrongfully collected. its salaries and compensation to its officers illegally paid, its public accounts improperly settled, and the judgment and sentences of its courts in civil and criminal cases null and void, and the officers who carried their decisions into operation answerable as trespassers, if not in some cases as criminals. Now, although these considerations cannot be brushed aside or ignored, the attempt by the courts to avoid involvement does not provide an assurance that the attempt is either likely to be successful or that it will prevent such tumultuous events ever happening. In the first place, to avoid deciding which government exists in the eyes of the law is in effect to decide in favour of one of the rival governments. Secondly, the need to apply the doctrines of necessity or effectiveness will arise regardless. Once a court may have to decide a dispute between the parties which will turn on the legal effectiveness of the decrees of the rival governments or parliament. This was illustrated by Luther and Borden itself, which involved an action in trespass against a government official appointed by the existing charter government. But perhaps the most important point is the realisation that the problems I have described will not arise at all if the decisions of the court are respected and obeyed. This in turn depends on the fidelity shown in any society to the rule of law and the decisions of the court. This is what I think will ultimately avoid the need to legalise any illegality, and not whether it is right for the courts to continue to ensure compliance with the law. The conclusion which I reach, therefore, is that the requirements of jurisdiction and standing may well be satisfied as long as they are not used as a disguised form of discretionary abstention, which I have never favoured. In my view, it is certainly dangerous to assume that our courts would not find in favour of jurisdiction or would not be willing to exercise it in an appropriate case which otherwise satisfies all relevant procedural requirements. Now, before I leave this aspect of the matter, I need to say something about a difference of opinion between Sir Garfield Barwick and Professor Winterton on whether an action to test the legal validity of the dismissal of Mr Whitlam would have given rise to a justiciable issue. Sir Garfield denied that it would have been justiciable, while Professor Winterton took the opposite view. As I've had occasion to mention elsewhere, possibly the difference between the two views is not as great as it may at first appear. Sir Garfield may have used the term non-justiciable in the sense that even if the court had jurisdiction to entertain an action commenced by the former Prime Minister, his dismissal by Sir John Kerr would not have given rise to any grounds for legal complaint, and the action would have been dismissed for that reason alone. This is essentially because the exercise of the power to dismiss ministers, in the view of Sir Garfield, under Section 64 was not subject to any relevant legal limitation. This is what I earlier described as the third ground for explaining why a court may find that it does not have authority to decide an issue. Professor Winterton, on the other hand, may have had in mind the first ground which I gave for the absence of such authority. This was the existence of jurisdiction over subject matter and the parties, and the ability to award legal relief. Now, the question was to be determined without preempting the outcome of any arguments which would seek to establish the existence of implied legal limitations on the exercise of the power to dismiss under Section 64 of the Constitution. At the same time, Professor Winterton may have been suggesting that arguments for implying legal limits should be accepted by the courts, even though this was, at the time he considered the matter in 1983, unlikely to occur because of judicial conservatism. This brings me now to what I regard as the real issue. That's going to be whether there are any legal constraints upon the exercise of the legal power to dismiss ministers under Section 64 of the Constitution, the issue which will now occupy the rest of this lecture. I turn to administrative law as the first relevant area of public law from which such a constraint could perhaps be derived. When Sir John dismissed the Prime Minister in 1975, he relied on Section 64 of the Constitution, which, so far as it is relevant, provides that ministers shall hold office during the pleasure of the Governor-General. It was understood, at least initially, that the term pleasure signified an absolute discretion, while the reference to ministers in Section 64 has, of course, always been understood to include the Prime Minister. There was unsurprising authority which suggested that the rules of natural justice did not, for that reason, apply to the exercise of statutory powers which were conditioned on the pleasure of the officials exercising such powers. But this would not have been the only consideration which militated against the application of the rules of natural justice. In the famous Australian Communist Party case decided in 1951, Sir Owen Dixon and other judges in that case accepted and followed the assumption that the principles which govern the exercise of discretionary powers confided in subordinate administrative officers or body did not apply to the exercise of similar powers vested in the Governor-General. Although it was not conclusive, the assumption informed the construction accorded to the legislation which was successfully challenged in that case. The challenge centred on the conclusiveness of governmental opinions, including those of the Governor-General, when those opinions formed the sole link between the legislation and the constitutional power which supported it. Finally, there was the point that the law relating to the application of the rules of natural justice to the exercise of prerogative, as distinct from statutory powers, had yet to develop by 1975. While the powers to dismiss Australian federal ministers and also to dissolve the federal parliament have always been contained in the Australian Constitution, a special kind of statute, such powers originated from English notions of the prerogative. It is against that background that Sir Garfield Barwick must have assumed that the rules of natural justice, or indeed any other restrictions, did not constrain the exercise of the power of the Governor-General to dismiss the Prime Minister in 1975. The balance of academic opinion pointed in the same direction. It is true that Professors Saw in 1977 and Winterton in 1983 suggested that Mr Whitlam could have challenged the validity of his dismissal on the ground that the Governor-General did not grant him a fair hearing. However, the arguments were seen by Professor Winterton as novel and imaginative. Both he and Professor Saw thought that the judicial conservatism would probably ensure that for the then foreseeable future the High Court would be unwilling to review the validity of a Prime Minister's dismissal by reference to the failure to grant a fair hearing. All this suggests to me that despite the availability of arguments to the contrary, a cautious and reasonably competent public lawyer would have thought, as did both the professors I mentioned, that it was almost certain that the arguments would not have succeeded in the courts. Mr Whitlam could afford to eat his chop in the lodge rather than go into the High Court, according to that view. But the equally, if not more important issue becomes what would be the position now if the events of 1975 were to be repeated today. Not that I'm urging for such repetition. Since 1975, there have been dramatic judicial developments which make it much more difficult indeed to rely on the earlier authority that I'd mentioned before, the utterances by Sir Owen Dixon. The developments consist of two important High Court decisions in 1978 which affirmed that the normal principles of administrative law could apply in relation to the exercise of statutory powers conferred on vice-regal representatives, albeit, of course, subject to some modifications. Those principles related to the need to exercise those powers in good faith and not by reference to improper or extraneous purposes, and also the need to comply with the rules of procedural fairness. This was so even though, in the case of the latter, special procedures might have to be adopted regarding how a fair hearing could be accorded if the relevant power was conferred upon the Governor in Council. There have also been dramatic judicial developments in the United Kingdom, which now mean that the question in that country no longer is whether courts in that country can ever review the way in which prerogative powers are exercised. The question today is rather different. It's which of those powers are not subject to such review because they are not thought to be susceptible or appropriate to judicial review. In other words, the prerogative nature of the power is no longer thought to be sufficient by itself to render it immune from judicial review. The current approach, as I think Professor Zines once said, leaves a lot to the discretion of a judge to weigh and balance the conflicting considerations in determining whether the subject matter of a prerogative prevents it being subject to judicial review. By 1985, it was still assumed that the dissolution of Parliament and the appointment of ministers, however, was not susceptible to judicial review. Little enclaves, if you like, that remain beyond judicial review. But it may be significant to remember that the dicta in question may have assumed that the exercise of the relevant powers in the United Kingdom are constrained only by constitutional conventions, a position which may perhaps no longer prevail in Australia, as will be seen later in this lecture. Australia, to me, seems to lag behind the United Kingdom in relation to whether the exercise of prerogative powers, as distinct from their mere existence, are subject to judicial review by reference to the ordinary principles of administrative law. That said, there had been one notable instance of such a case decided by the Victorian Court of Appeal in 1995. Moreover, it is now dangerous to assume that the High Court will automatically reject the application of the rules of procedural fairness to powers which are exercised at the mere pleasure of the person or the official exercising them. However, the unwillingness to subject the power to appoint and therefore also to dismiss ministers in the United Kingdom has been followed and applied in this state. In 2009, the Court of Appeal refused in Stewart and Ronalds to accept that the exercise of the corresponding power conferred by the New South Wales Constitution on the Governor was constrained by the rules of procedural fairness. The High Court has yet to rule on whether the exercise of the power contained in the corresponding provisions in the Australian Constitution are going to be constrained by the rules of natural justice. All of that notwithstanding, there is much to be said in favour of the view that the powers granted by Section 64 of the Australian Constitution should, from a merely moral point of view, be exercised with reasonable fairness. But the key question, of course, remains whether that duty should be enforceable by the courts so as to assimilate the position of a head of state to that of a subordinate administrative officer or body. Or is such a duty better left to the development of constitutional conventions and the political processes? The answer to the question may implicate and reach into the exercise of powers by reference to extraneous purposes and good faith, and also the powers to dissolve the Parliament under sections 5 and 57 of the Constitution. It will be clear from what I've said that despite the dramatic changes that have taken place since 1975 in the judicial review of executive and administrative action, it is still doubtful in the present state of the authorities whether courts are ready to take that final step of assimilation. Neither can it be confidently asserted that the taking of the same step is inevitable, since some judges may still feel that the exercise of such discretionary powers is not susceptible to a judicial review. But even if those rules do not apply, is it possible to conceive of a different and much narrower form of judicial review which will be more appropriate for the review of the exercise of constitutional prerogative powers, not mere statutory powers, which have to be exercised in accordance with the conventions of responsible government? That is a question. This would, if it was answered in the affirmative, involve and be confined to implying a legal duty imposed on the Governor-General to warn a Prime Minister about the impending exercise of the power to dismiss the same minister. I can now turn to the other area of the law from which a constraint on the power to dismiss ministers could perhaps be derived. The framers of the Australian Constitution assumed that powers such as the power of the Governor-General to appoint and dismiss ministers would be exercised in accordance with the rules of constitutional convention derived from the British principles of responsible government. Peter had adverted to that in his introduction. Sir Kenneth Weir has provided us with a good working definition of convention for our purposes. According to him, a convention is a rule of behaviour accepted as obligatory by those concerned with the working of the Constitution. In the United Kingdom, such rules are not legally enforceable, despite the troublesome distinction which exists between their enforcement, not permitted, and their mere recognition and taken into account. The same rules did become legally enforceable in some British Commonwealth countries that obtained their independence after the Second World War. In Australia, and before 1992, my understanding was that, leaving aside sections 62 and 64 of the Constitution, which did make some aspects of responsible government legally binding, the Australian Constitution was structured to make it possible to permit but not require compliance with the principles of responsible government. With some exceptions, they only applied according to their tenor, that is to say, as mere conventions and not legally enforceable rules of law. Conventions had the disadvantages of vagueness and uncertainty and the advantage of flexibility, which allowed them to evolve and develop without reference to the electors voting at a referendum to amend the Constitution. Now, the failure of the framers to incorporate other aspects of responsible government, apart from those explicitly incorporated in the Constitution, may suggest that the explicit aspects were the only aspects that were intended to be legally binding and enforceable. Now, that's going to contrast with the model of self-government surprisingly adopted for the Australian Capital Territory in either 1987 or 1989. I can't remember the year. But before then, and according to the traditionally accepted view, any conventions which surrounded the exercise of the powers of the Governor-General to appoint and dismiss ministers would not, as I say, according to that traditional view, have been legally reviewable or enforceable in 1975. Now, whatever misgivings I may have, the position may have changed after 1992. Some of the conventions of responsible government may have become transformed into rules of law so as to become constitutionally entrenched. No doubt Professor Dicey would be turning over in his grave if that comes to be true. I need to distinguish here the Canadian Supreme Court advisory opinion in 1982, which deals with the practices that govern the amendment of the British North America Acts by the United Kingdom Parliament. It was acknowledged in that case that the existence of conventions raised a justiciable, at least for the Canadians, and not merely a political issue, because to declare the existence of the conventions was essential in defining the whole content of constitutional law when understood in the British sense. Although this still involves some modification of the British understanding of conventions, that's what was happening in Canada, it is important to realise that even there, their existence was recognised only according to their tenor, only as conventions and not as legally enforceable rules. Now, be that as it may, it seems highly arguable, I think, that the High Court would now be willing to draw implications from provisions in the Constitution which partially recognise the system of representative government known as responsible government. An important implication was drawn from the system of representative government, as we probably all know, in favour of the guarantee of political free speech in Australian Capital Television Proprietary Limited versus the Commonwealth in 1992. Now, the possibility of drawing implications from responsible government was suggested in the very same year in the twin case of Nationwide News Proprietary Limited versus Willis. Justices Dean and Toohey in that case referred to the possibility of deriving implications from, quote, the general doctrines of government which underlie the Constitution and form part of its structure, given the fact that the doctrines of responsible government, amongst others, can arguably be seen as a main general doctrine underlying the Constitution as a whole. Now, Justice Brennan, who I'm very pleased to see in the audience tonight, made similar remarks in that case. There are, in addition, clear remarks in the unanimous judgment of the High Court in Longy versus the Australian Broadcasting Corporation, decided in 1997, which strongly point in the same direction, such as the ample reference made to provisions which either partially recognise responsible government or could not be understood without reference to those principles. There are also remarks which are cited in the written version of this lecture which begin by stating, quote, whatever the scope of implications arising from responsible government. In addition, the unanimous court emphasised the legitimacy of drawing implications from the text and structure of the Constitution which embodied such institutions of government as representative and responsible government, as long as the question asked was not what was required by those doctrines, but what did the terms and structure of the Constitution authorise or require? Very subtle distinction, which is sometimes ignored. Finally, in this connection, and by no means the least important consideration, it is difficult in principle to distinguish between the ability to draw implications from representative government and those from the particular kind of representative government known as responsible government. Against that background, and so far as responsible government is concerned, Perhaps the ultimate test needs to focus on the provisions of Section 62 and 64 of the Constitution, which expressly provide for the need for ministers to be members of Parliament and the Executive Council. That's the body which advises the Governor-General in the government of the Commonwealth in formal terms, at least. That test is whether those provisions can properly be understood without implying into the Constitution the purpose usually served by such provisions, namely to enable the operation of the core principles of responsible government. Although not conclusive, it does need to be remembered that this was one of the ways responsible government was recognised in the 19th century, most notably in the colonial constitution of the province from which I come, South Australia, which served as the model for the corresponding provisions in the federal constitution. It also needs to be remembered that the requirement in Section 64 that ministers must be members of Parliament within a certain time so as to be answerable to Parliament is framed in mandatory and not merely permissive terms. It will be clear from what I've said that I disagree with the criticism made by another commentator that my views can best be regarded as interesting speculation rather than what the law is or is likely to be. If my analysis is sound and the commentator is wrong, it would seem to be highly arguable that some rules of constitutional convention have now become transformed into rules of law so as to become constitutionally entrenched. It's a view shared by leading commentators in their evidence to the Joint Select Committee on the Republic referendum in 1999, who thought that the reserve powers and the conventions which regulated their exercise are subject to judicial review, at least to the extent that they exist for the purposes of furthering representative government. One of those commentators was, of course, Professor Winterton, and another was, yet again, Professor Zines, who I'm very especially pleased to see here tonight. Once the conventions are regarded as legally enforceable, they can, in my view, only be changed by formal amendment of the Constitution under Section 128, subject perhaps to two practical qualifications, the first being the principles of progressive interpretation and the difference between the accidental and essential meaning of constitutional terms, despite the criticisms that are sometimes levelled at that distinction. Unlike Professor Winterton, I have had more doubt than him about whether the Parliament could alter the rules which govern the exercise of discretions vested in the Governor-General under Sections 5, 57 and 64 by ordinary legislation passed under the incidental power in Section 5139. Now, those principles of progressive interpretation I have mentioned may help to partially offset the loss of the advantages of flexibility and the capacity to evolve and develop when the conventions only operated as conventions. The disadvantage of vagueness resulting from their enforcement as law could be met by the difference between the accidental and the essential meaning of constitutional terms and the emphasis placed in the Longy case on what the terms and structure of the Constitution prohibit, authorise or require. Now, the foregoing analysis makes it essential, obviously, to isolate which principles of responsible government will be seen as part of the Constitution in the relevant sense. Professor Winterton was right when he recognised that while the core of the British principles of responsible government is clear, the edges are fuzzy and ill-defined. Now, putting those fuzzy edges aside, the essential or core elements of the concept can be clearly stated. First, the Crown's representative should act in accordance with the advice of ministers who are members of the Parliament, subject to the reserve powers enjoyed by the Crown's representative. And secondly, those ministers must command the confidence of the House of Representatives. If both these core principles are now legally enforceable, it will vindicate a view expressed by Professor Winterton even before Nationwide News, Australian Capital Television and Longy were decided. Now that brings me to the thing that perhaps attracted some of you to the talk tonight. That namely the blocking of supply by the Senate, which culminated in the dismissal of the Whitlam Labor government in 1975. Elected upper houses pose obvious problems for responsible government if the view is taken, as I think it should, that ministers need only enjoy the confidence of the majority of the House of Representatives and not the Senate as well. The problem is created by the Senate having and exercising the power to refuse supply. Clearly, the years that the years that have passed have not settled whether Sir John Kerr was justified in exercising his reserve powers in dismissing Prime Minister Whitlam and ordering early elections for both houses as a means of resolving the deadlock over supply. As I've explained elsewhere, the controversial events of 1975 were to open up an intense debate which ranged over a wide spectrum. Now, it's not the place to undertake a fresh examination of that debate or an exhaustive description of it, which has been sufficiently dealt with by others. But a broad outline is still necessary for my purposes, which shouldn't last very long. At one end of the spectrum, there were those who argued that the reserve powers to dismiss no longer existed. At the opposite extreme were those who believed that it did exist and was correctly exercised by Sir John Kerr. In between those two positions was the view favoured by others, including myself, and that is that the reserve power did exist, but it wasn't correctly exercised because it was invoked prematurely and the then Prime Minister was not adequately warned about its impending exercise. Of course, there have been replies to these arguments, but it's unnecessary to pursue them here tonight. The basic rationale used by Sir John Kerr and Sir Geoffrey Lindell for justifying the existence of the reserve powers to dismiss a Prime Minister whose government enjoys the confidence of the House of Representatives but is refused supply by the Senate can be summarised in the following way. First, a government which has been denied supply by a popularly elected lower house of Parliament can be dismissed if it does not resign or agree to go to an election. Secondly, the same principle must apply, it was argued by analogy, if supply is denied by a popularly elected upper house as a necessary consequence of the parliamentary control over appropriation and expenditure and of the natural expectation that the ordinary and necessary services of government will continue to be provided. The first of these principles was uncontroversial and was obviously derived from the system of responsible government developed in the United Kingdom, where the upper house was not elected. The second principle, however, is in a different category. It was seen as analogous to the first, an analogy rendered necessary, it was argued, by the powers vested in and the elective nature of both houses of the Australian Parliament. Like others, I believe that Sir John Kerr and Sir Geoffrey Lindell created a new principle for which there was no precedent. My own view is that the analogy is suspect, a view shared by others, including, of course, Professor Winterton. The power to dismiss a Prime Minister in the circumstances which arose in 1975 can and should be derived independently, I believe, of any analogy founded on the system which operated in relation to the United Kingdom Parliament. A preferable way of justifying the power is to treat the power of the Governor-General as a solution of last resort, deployed by a constitutional umpire in the event that the political processes have proved unable to resolve any impasse over supply. This can be done, I think, without relying on any notion of responsibility to the Senate, or, if we leave aside any question of illegality once the funds run out, or without implying any criticism or disapproval of a government that is unwilling to resign if it has continued to govern when it enjoys the confidence of the House of Representatives despite supply having been refused by the Senate. It is a solution of last resort necessary to continue the provision of the ordinary and necessary services of government. It's also consistent with, but I wouldn't wish for it to be derived from, the provisions of Section 61 of the Constitution, which provide that the executive power of the Commonwealth vested in the Governor-General extends to the execution and maintenance of the Constitution. Now, although resort to the judgment of the electors is democratic, who could deny that, the solution may not be satisfactory if the deadlock over supply is not accompanied by deadlocks in respect of other legislation sufficient to ground a dissolution of both houses under Section 57 of the Constitution, as distinct from only the House of Representatives under Section 5. Be that as it may, the conduct of these arguments took place for the most part on the assumption that once the Governor-General had the legal power to dismiss the Prime Minister under Section 64, the propriety of the exercise of the power, by reference to the considerations I've outlined, was not a legal question, but one of convention in the traditional British sense, albeit the need to adjust those conventions in their application to Australia. After 1975, it was natural that attention would turn to whether, as Dr. Evatt had once suggested, these conventions should be codified. Despite surprising agreement reached at the committee level, the attempts by the Australian Constitutional Convention to codify the conventions in this area ultimately failed. The competing views about the propriety of Sir John Kerr's actions proved a major stumbling block in the way of treating the precedent created by 1975 as a settled convention for the future. This has left unresolved the problem of what would happen if the episode was ever to be repeated. I've argued elsewhere that the awesome nature of the consequences of the exercise of the power to reject supply by the Senate and the uncertainty about the propriety of the exercise of the power to dismiss provide a kind of safeguard against its repetition. In other words, and looking at the world through North American eyes, it is as if the absence of a solution provides for its own solution. However, what was previously an issue which turned on the interpretation of conventions may now be seen as a question of law in the light of comments made in nationwide news and longing regarding the effect of entrenching at least some aspects of responsible government under the Australian Constitution. What begins as the relatively simple matter of giving effect to an essential element of responsible government, namely the simple duty of the Governor-General to act in accordance with the advice provided by ministers who command the confidence of the House of Representatives, is then, however, going to necessitate a much more detailed examination of the exceptional circumstances in which the Governor-General does not have to act in accordance with that advice, the so-called reserve powers. Judicial intervention would then give the High Court the ability to resolve and settle as a strictly legal matter some aspects of the debate that I've described. In short, the debate is whether a government can be lawfully dismissed by the Governor-General under Section 64 of the Constitution when the government enjoys the confidence of the House of Representatives and refuses to advise an early election, notwithstanding its inability to secure supply in the Senate. Well, mercifully, you'll think I can now bring my unexpected journey to a close by observing that it would be both interesting and fascinating to be able to see how the High Court would resolve this issue, which has so far eluded political solution.
Thank you very much, Professor Lindell. Since you have indeed left us a little time for questions, you may in fact have the opportunity to hear how High Court justices would consider your propositions here, as we have many, some existing and former justices of that esteemed court here. May I invite anyone to ask any questions or perhaps propose any comments to Professor Lindell? Yes.
I don't really recall the exact things that happened in 1975, but I don't remember the sacking. But could you remind me, did the Governor-General sack each and every minister that had been appointed before finally sacking the Prime Minister?
Okay. No, the way it was done was that that fateful document that was handed to Mr Whitlam, which was face down until he refused to agree to an election, I think talked about the dismissal of the government, and certainly the statement that he later published explained that by sacking Mr Whitlam, he was in fact dismissing the whole government. So it wasn't a process that you had to go through individually with each minister.
Any other questions, comments? You've obviously... oh, yes, one there.
Thank you for that very interesting talk, Jeff. Whenever I try to think about this issue, my gut feeling leads me to a solution where there would be judicial review if the Governor-General committed something which you could call Wednesbury unreasonableness, or indeed going beyond that Wednesbury ridiculousness.
Yes.
I just wonder how you could construct a justification for that out of the doctrines you've been talking about.
Well, I certainly don't try to, and it's something that has given me great difficulty. The best that you could get out of my talk tonight and I hope to elaborate it later in some, perhaps write in an article, is a duty to warn. That's about as far as I'm prepared to go, and you'll notice that I wasn't really deriving it from administrative law in the end. I squirmed a lot when I tried to think about it, but in the end I was only able to derive it from the conventions of responsible government, if you like, a duty that is implied from fairness, rather than to tap into the existing doctrines of administrative law. Now, why am I reluctant to do that? If we start bringing into play the ordinary doctrines that apply to ordinary officials, then we have some interesting questions, don't we? For example, let's take the business about good faith and acting with regard to extraneous circumstances. As Dr. Jim Thompson once said, I think in a publication, if you can apply those doctrines, well, could it not be argued that in fact one of the motivating factors in the dismissal was Sir John Kerr's worry about his own position? Now, of course, we have Sir John's answers to that he wasn't worried about his own position, he was worried about the Queen. But the very fact that we can then have an argument as to whether who is right when we try and delve into his mind makes you wonder whether courts want to really get involved in conflicts of that kind. So rather I steer away in the end from applying administrative law principles. And when I say I steer away, I'm thinking about what judges are likely to do. I think we've gone a long way. We've certainly eroded a lot of the edifice upon which Sir Owen Dixon had rested his remarks about not applying those doctrines. But perhaps in the end we'll find that some of that residue still remains by the courts asserting that they can intervene in certain cases, but they're not going to apply the same rigorous standards that apply when it comes to ordinary administrative officials. And that might also have an impact, I think, on the extent to which a court might actually, from the point of view of responsible government, start second-guessing, should the Governor-General have waited longer? In other words, did he act prematurely, as I and others argued? No, I don't think courts will want to second-guess that kind of decision. They might not even want to second-guess from whom that person, the Governor-General, got advice outside the government. On the other hand, the value of the courts intervening in the way that I've talked about through the channel of responsible government is that the court is there. It acts as some sort of a check, that no longer can you assume that the Governor-General is completely at large in the exercise of such awesome powers.
Thanks very much for a fantastic talk, Jeff. Two questions really. One is, given the sort of politically charged nature of what happened in 1975, do you foresee it as reasonably possible that a government in the position of the Fraser, not a government, the opposition, the position of the Fraser opposition at the time, would employ similar tactics on either side, Labor or Liberal? And secondly, given the controversy and the difficulty of this issue, what would you suggest as the sort of preferable solution? Would it be a codification of the reserve powers or something else?
Do I foresee that happening again? Shortly after it happened, I, along with many other people, I think, were really quite concerned that this would happen depending on the state of the public opinion polls, that government oppositions who would see their position rising in the polls would do what happened on that occasion. Well, 30 to 40 years have passed and that hasn't happened, but you'd be a fool if you thought it couldn't happen again. So I think that's my position on that. I'm not very good at trying to read the minds of politicians. That's never been my strength. But all I can say is that is a possibility. Now, as to what you do about it, well, a lot of us provided advice and suggestions to the Australian Constitutional Convention, and we went up and down Dale trying to look at ways in which we wouldn't have this. There are several ways, obviously. From a purely theoretical perspective, you'd take away the power to reject supply. But then, the moment you have that sort of proposition, out they come. The rival contending parties that debated back in 75, even those who don't know much about what happened in 75, are likely to come out again, and they'll probably object to taking away that power from the Senate. I personally remain in favour of taking that power away, but I have no illusions about whether that would carry at a referendum. So what other amendments would you think about? The simultaneous elections for both houses would not really go to the heart of the problem, but it would make it less likely to happen because you have at least half the Senate more in tune with the wishes of the electors at the last election. And that was one of the problems in 74-75. Then there are, I suppose, and I think Professor Winterton discussed them, the possibilities of trying to, in effect, get supply assured at the start of the life of each parliament. Now, legally, there may be problems about that. Ordinary annual services of government is referred to in section 53, but it's not realistic, I think, to think that that will be accepted either. So you mentioned, I think, codification. We've tried that. And if you look at the Constitutional Convention debates, now the Constitutional Convention met between 73, I think, to 1985, and one of its very important objects was to try and do just that. And experts were deployed, Professor Winterton and other people, including myself, and we did a lot of work, and Professor Saunders as well did a lot of work. We thought we were getting somewhere when agreement seemed to have been reached at the committee stage, until I think the Labor backbenchers found out what Gareth Evans had agreed to, and there was hell to pay, because it all came back, 1975, all came back. The fact of the matter is we did codify quite a lot of the practices and conventions in Australia, but as I think Mr Greiner was to say, the codification exercise is definitely silent on this problem, simply because you couldn't agree about whether Sir John had acted correctly. So while theoretically that remains an option, and I'm sure Dr Everett in his grave would be supporting it, it still faces those difficulties.
Professor Symes.
You may have covered that what I want to raise. If so, I would have missed it because of my poor hearing. Now,
usually not.
Assuming the court accepts to apply notions of fairness or natural justice to the dismissal of the Minister by the Governor-General, would you wish to draw a distinction between that and other grounds of judicial review? For example, improper purpose. If so, why?
Yes. Yes, I would, and in fact I was doing it a moment ago, probably not to perfection, but I'm hesitant about applying those other grounds. When we look at the exercise of prerogative powers being reviewed, there seems to be this acceptance carrying over from British understandings that that's not an appropriate function for courts to be applying that at that level. I think the duty to warn seems to me to be exceptional. It is a universal value which appeals and can be understood by lawyers and non-lawyers alike, although it's lawyers who seem to be particularly worried about it. On the other hand, the other matters I think are more appropriate when you're dealing with subordinate officials. Yes, Mike.
Should that correspondingly lead to a restriction on the sources of advice that the Governor-General could call upon, namely High Court judges, in determining their own?
Okay. Well, I would say that the question as to who advice is obtained from, for everyone other than serving judges, would probably be left in the discretion of the Governor-General. In the explanation I gave a little earlier, I perhaps should have emphasised that I see the court according to the Governor-General what the Europeans call a wide margin of appreciation, a wide margin of discretion. And I think the question as to who advice is obtained from would probably, in most cases, be left up to the Governor-General. On the other hand, when we start talking about judges, and particularly serving judges, I'm not so much concerned with retired judges. I think we're entering into a field where the courts have already indicated their concern about what judges do. Some years ago, I probably would have confined my answer to serving federal judges. But today, because of cases like Cable, I'd now have to widen the net to include state court judges. So that is something that doesn't flow from what I've been talking about tonight, but rather the developments under Chapter 3.
I wonder if you'd mind giving a comment on the propriety of the secret advice given by Barwick and Mason beforehand, which had an effect on the outcome.
Well, I'm not going to add very much to what I think Professor Anne Toomey has already said on this subject. Look, there's no doubt that if we're talking about the standards that prevail today, as the Chief Justice has indicated, that's Chief Justice Bob French, I don't think that can happen today. But it's very easy to view those events through today's spectacles, and today's spectacles rule it out because the courts have been quite energetic in developing notions of the separation of judicial powers and Chapter 3. Now, as to whether it was proper at that time, I suspect it probably wasn't. But nevertheless, it's very easy to say that. Remembering, nevertheless, as Professor Toomey has pointed out, that there'd been quite a history of involvement of judicial officers providing advice to vice-regal representatives.
It's just the very principle that it's in secret and only persists one party.
Well, I think some of them were in secret. Obviously, if it's done with the consent of the government of the day, there's no problem. But I don't think some of the things that the advices that Sir Arne Dixon would have given to the Victorian government, I think that may have been one such incident. I don't think that was publicised. I think, in a way, it's a sort of a hangover from the 19th century role and the failure to separate out what judges do. And even in by the time Cable's case is decided, we're still recognising that judges can become lieutenant governors. Now that's pretty recent, and I find that very difficult to square. So my warning to people who make quick, harsh judgments about what happened is that it's easy to see things through today's spectacles.